Everyone, welcome to this webinar organized by the Competition Commission of South Africa. It is to dissect and discuss the recent, what I think is a seminal decision by the Competition Tribunal in a matter involving the Competition Commission and Babelegi Workwear Industrial Supplies CC. This case is quite important for many reasons. Firstly, it is a first that the Competition Tribunal has concluded a contested matter in such short notice. It is a first for the Competition Tribunal to apply the amendments to the Competition Act that were passed last year by the President. As you know, they have introduced quite significant changes, particularly on excessive pricing. And in particular, they have rejigged the definition of excessive pricing by deleting what was the problematic definition from many circles, which required authorities or those that were taking on cases to establish what an economic value of a product ought to be. The new law now adds various other dimensions, requiring the tribunal, giving it what I think is quite a broad scope to look into practices of excessive pricing. It can consider the relevant factors as listed in the Act, but it can also go beyond that and look at other factors. And this is the case where the tribunal has made that clear. It has applied its discretion and has given so much weight to the effects of the conduct in the light of the pandemic, as you know it, COVID-19. There are issues that arise from this judgment around market power. What is market power? What is the role of market shares? What do they mean in cases like this? You will recall this company probably had a market share of just around 5%, but what mattered on this matter was the dominance and exercise of market power that the Commission alleged, and the tribunal found in the Commission's favor on these. I've also read recently, which is today, an article in the GCR quoting Mike Walker, a UK CMA's chief economic advisor, who says in his view, and I quote, "The tribunal has done a really good job," and close quote, because he thinks in times of pandemic, we have to apply tools creatively. And I believe in the UK, they are watching this conduct quite closely. There are legal issues that arise from this case, and I do have a distinguished panel to dissect both the legal issues and the legal implications that arise from this case. There's a penalty. I've had a couple of people saying it's such a small penalty, but is it about the penalty? My view is it's about the conduct. The conduct took place for a month. We do expect penalties to be at the level where they are. But without further ado, I'll introduce to you the panel. My panel really requires no introduction. I have Professor Massimo Motta, who is a research professor at ICREA, Universitas Pompeu Fabra, and at the Barcelona Graduate School of Economics. He founded the Barcelona GSC's Masters in Competition and Market Regulation, and he is on the steering committee of this master. He served as chief economist of the European Commission from 2013 to 2016. He has extensive experience in advising competition agencies on cases and policy, in teaching competition policy to lawyers, economists, and supervising doctoral dissertations. And you will note in the judgment that his article in the Daily Maverick is quoted extensively. And he will share more about that. He had already shared that with on a similar session earlier, I think a month ago. I have Pamela Mondliwa, who is a senior researcher at the Center for Competition, Regulation and Economic Development at the University of Johannesburg. Prior to joining CRED, she worked as an economist in the Policy and Research Division of the Competition Commission of South Africa. Pamela's research interests include competition and access to markets, industrial development, and regional economic development. She has provided research support to various government departments and advises competition authorities in the region. She's also a member of Gauteng Premier David Makura's Economic Advisory Panel. I should also note, whilst at the commission, she worked on the Sasol matter, which went all the way to the Competition Appeal Court, and I think it's a homecoming to Pamela, and we'll hear from her what she thinks of these recent developments. I have Candice Lamp, who is entered private practice as an advocate in Port Elizabeth on 19 June 1999. She has held numerous appointments as an acting judge of the High Court in the Eastern Cape Division. She joined the Competition Commission as manager litigation in November 2017. Candice regularly appears on behalf of the Commission in the Competition Tribunal. She formed part of the team representing the Commission in the Babelegi matter. You can see I have people that represented the Commission, experts in the field that will dissect this matter for us. We have Nkonzo Shatswayo. He's no stranger to the Competition Commission. Long time. He was head of the Mergers and Acquisitions Division, but I'll take you through his profile. Nkonzo is a director and head of competition in Africa practice at Lawtons Africa. Nkonzo has considerable experience in competition law spanning over 21 years, having been involved in the development and evolution of competition law in South Africa and other parts of the continent. He is particularly qualified to advise on competition law issues on the continent. He also served as the chairman of the Swaziland Competition Commission. He was a lecturer in law for several years, teaching company law, constitutional law, and the law of property. He has published academic articles and co-authored a book on human rights. Welcome again, Nkonzo. This is your second home, I believe. You have been with us for quite some time. James Hodge is the chief economist of the Competition Commission. He joined the commission from Genesis Analytics, where he has been the managing partner of the competition and regulatory economics practice since 2005. Prior to that, he was senior lecturer and postgraduate convener at the University of Cape Town's School of Economics, as well as senior researcher at UCT's Development Policy Research Unit. I also met James at Wits University when he was my lecturer, but I don't see it here in his profile. He has a huge depth of experience, having provided expert economic advice and reports in hundreds of cases across the full spectrum of economic sectors and in a number of Southern and East African jurisdictions. And finally, and last but not least, Professor Philip Sutherland. He is co-director of the Center for Competition Law and Economics and Professor of Mercantile Law at Stellenbosch University. He holds a PhD from the University of Edinburgh and BCom and LB degrees from Stellenbosch University. Philip has published extensively on competition law, corporate law, and financial regulation. The broad objective of his research is to determine how to balance the needs of businesses and the interests of those who may be harmed by business activities. He has been a member of the Financial Services Board since 2002 and head of Department of Mercantile Law at Stellenbosch University from 2012 to 2016 in the area of competition law. Philip is a co-author of the Competition Law of South Africa. It's quite an important piece of literature. This, if you have not read it, please take a challenge today, get a copy for yourselves. His research is currently focused on competition law theory and enforcement. Ladies and gentlemen, my name is Hardin Rachisusu, Deputy Commissioner of the Competition Commission. I'll simply be the moderator for this session. So without further ado, I will hand over to Philip for his opening remarks on this seminal case. What does it mean for competition enforcement and regulation, not only in South Africa, but globally? Philip, over to you.
Thank you very much, Hardin. Thank you very much for the invitation and for your kind introduction. And of course, I think congratulations to the Commission is in order for this judgment that, I mean, is clearly not, people would think that this would not be a very easy case to make out, and your success here is certainly noted. So what I want to do, perhaps I want to just briefly mention a few of the major aspects of the case, and then perhaps we can look at some of them in greater detail. So for me, the first point that is important here is that, of course, a specific regulation has been enacted to deal with price gouging in the context of the emergency. I think it's generally known as the Consumer Protection Regulation. And I suppose in future, many of the cases will still deal with the standards set out in that regulation. But of course, this Babelegi case doesn't deal with it at all, because the price increases that took place here took place before that regulation came into effect. And I think in a sense, the Consumer Protection Regulation is a victim of its own success, in the sense that I suppose, and the Commission can correct me, but many of the complaints concern that period before the regulation came into effect, because the regulation served as a warning to many of the firms. So the case is therefore very important because it deals with the provisions of the Act itself on excessive pricing. But it's also going to be very important in future, although the case doesn't really assist us with that, in determining the relationship between the regulation and the provisions of the Act, because the regulation also talks to the Act. And I think that's still going to be difficult to do in future, although it may in some cases be easier for the Commission to simply now rely on the Act itself and to simply use those tests set out in the regulation as a sort of background issue. One of my concerns here is that although the Tribunal says it does not apply the regulation, one could perhaps in some ways argue that they have slipped it in by the back door. That could be in some ways problematic. The second issue for me is that this Babelegi case is, of course, the first case that deals with the amended provisions on excessive pricing. The provisions were amended they came into effect on the 12th of July 2018, and the Act says many important things about this, about these amendments. So that's the interesting thing about South African excessive pricing law. In the past, the most important case concerned a very small market for knock and drop newspapers in the goldfields of the Free State, and now we have this case concerning a fairly small player in the market for face masks that sets the standard here. And I think there are a few important issues for me that one can look at just in terms of broadly defining the new excessive pricing provision and what the Act says about that, or what the Tribunal says about that. The first thing that strikes me about the Tribunal's view is the Tribunal says that the Act now is more discretionary. I'm not sure whether I agree with that. It seems to me that the Act now sets out a different test. It replaces the old test of economic value and bearing no reasonable relationship to that with a new test that requires firstly that you have to determine the price that would have been charged in a competitive market, and to then determine whether the price that was actually charged is unreasonable in relation to that price. In the Sasol Chemical Industries case, the court said the first aspect under the old Act determining economic value did not concern a value judgment, and I think that still is true about determining whether it's a competitive market, and in that sense I think it's not necessarily discretionary. And then the court said the bearing no reasonable relationship aspect, that involved a value judgment, and I think that's still true about reasonableness. What is different now is the Act sets out criteria, and I think the Act now requires perhaps a less strict test. Reasonableness is perhaps less strict. I also think the Tribunal makes some interesting points about the relationship between the old test and the new test, and the Tribunal also takes the view that the old test is not that different from the new test, and I think that is quite useful. Then I think the next point that I quickly want to look at is the issue of dominance here, and how dominance is determined here. And I think that perhaps is, in this case, the most important aspect of this judgment. In the past, there was a judge in the Cape High Court who was called Necessity, and he was called Necessity because they said necessity knew no law. Now, in a sense, I think this is what we are dealing with here as well, is in a way, the question is to what extent necessity in the sense of an emergency like this can raise special issues regarding how one determines a dominance. And the Tribunal here applies the arguments of Professor Motta that he raised in an article in the Daily Maverick, and they take the view that a firm can be dominant if there's a surge in the price or surge in demand. So this term surge in demand is used very often, and especially if there is if there's also a difficulty with supply, because in that situation other competitors would not be able to respond to increases in prices. And this is the argument that the Tribunal then uses to say that in this case the price is excessive. Now, I must say this idea of emergency dominance has specifically been rejected in US law, in the agrochemicals case, and in a Brook Group case. And I think it's important to relate the two. And I'm not sure that I'm convinced by this argument, but I think the Tribunal makes the best kind of argument for this particular view, and it's also something that we can discuss later. The second issue, I think, here is the issue of the fact that the period here over which dominance is determined is a very short period. Again, I think there's very grave difficulties here with false positives, but I think the Tribunal's view that again, the emergency sort of means that you have to look at things in slow motion. Again, in my view, could be a convincing argument here. One of the things that bother me a little bit here is this: in this case and in many of the other aspects of the in many of the other arguments, the Tribunal refers to the issue of price gouging. And I'm a little bit, I think a little bit greater care should be taken in comparing the price gouging law, especially as it's applied in the US, with excessive pricing. And I'm not sure whether the Tribunal has really done so with sufficient care. So it's something perhaps we can look at. Another important point is the Tribunal does not do a market definition here. And it argues why it's not necessary. I think that's perhaps an issue that we can raise and talk about a little bit. The tribunal says market definition is going to be difficult in an emergency situation because of changes. I'm not sure, and I think it may even in some cases be more important to look at market definition. I'm also not sure whether the cases the tribunal referred to are quite convincing. When it comes to abuse, of course, I think the most important argument here is the high increases that prevailed here. For me, the most important question here is to what extent changes in demand should be taken into account, and whether that was sufficiently done here. And I think one can, in one sense, put this case aside a little bit because the increases here are fairly stark. But I think some of the focus on the economic test here, which is simply to compare the prices, cost, and margins before and prices, cost, and margins after, could be more problematic in other cases, and I think one should be more careful in assessing the impact of demand as a driver of price. The other aspect that I think perhaps could have been a little bit more carefully considered is the extent to which cost is a determinant of the increases in price here. So the tribunal's view is that this is a retailer and they really look at just direct costs. I'm not sure whether I agree with that, especially in the light of the Sasol case. I wonder if one shouldn't take a broader view of costs, especially if you consider this is a small firm facing a grave uncertainty, and whether the uncertainty and the approach of its suppliers should not have been more carefully considered there. Then I have two more points. The first point concerns the fact that Section 8 requires also that there should be detriment to consumers or customers. Now, the old Section 8 only required detriment to consumers. And the argument in the past was this is not a very important requirement, because if you can prove excessive pricing, generally you would prove harm or detriment to consumers. But the court said, the CIC said, you have to distinguish here between purchasers and consumers. So the Act was now amended to specifically include both detriment of consumers and purchasers. The tribunal has to wrestle with this issue. And I think it does so quite convincingly. But for me, the outcome of this is that this issue of detriment as a separate aspect that has to be tested for will in practice be of limited or almost no relevance. So this part of the Act, I think, merely directs the purpose of the Act rather than setting a different requirement for the Act. And then my last point concerns, in this case, the fine. So people may say the fine is fairly small, but I think if one considers the profit that was made here, it perhaps isn't. I'm not quite convinced by the methodology used by the tribunal here. The tribunal goes through the steps required for determining fines in South Africa, but then it sort of ignores those steps, and it simply takes the in this case the amount, the profit made from the excessive pricing, and it adds 1.5 times that amount. And I'm not sure whether that aspect of the case will stand on appeal. So although I think many of the other aspects have a 50-50 chance, this aspect to me, I think, is probably going to be problematic. The last issue perhaps that I can mention is procedural aspects. So this case was decided in terms of the very short procedures also required by special regulations. And of course, that creates some of the difficulties regarding evidence and so forth. There were special aspects that allowed the tribunal to do that here, but I think in other cases that also are decided in terms of the Act, it may be very difficult to enforce the special procedures as set out in the regulation, where the Act itself is applied without looking at the consumer protection regulation. So those are my points. There's a lot more, of course, that one can say about this case, and we're going to be busy with it for some time. But I think it again shows that South Africa, when it comes to competition law, is on the cutting edge, and it makes me very happy to work into this area of law.
No, thank you very much. Thank you very much, Professor Taleng. So I will. I think on that note, I think you have raised. I just don't want to put Candice on the spot because she's been the lawyer on the matter, but I think she can, if she so wishes, she can respond to some of the things you have said. But it's really what her sort of impressions are on the judgment. What are the key take home from her side, and how significant those are. So, Candice.
Thank you, Hodge. I think what I can say is that it is particularly gratifying that the Commission was successful in prosecuting the matter, taking into account the fact that this was an entirely in-house matter. So from investigation to litigation, and the economic evidence that was led was all presented by employees of the Commission, and that I think is a great success. As you've already indicated, this definitely is a seminal judgment. We are going to be using this case as a point of reference or guidance in extensive competition matters going forward for many, many years. Yes, there is a very strong possibility that this matter is going to be going on appeal. It certainly doesn't appear at this stage that it's being brought, that there's any urgent appeal that's going to be brought. So it'll be some time before we have settled finality in respect of what is going on. But as matters stand at the moment, this judgment sets the standard in respect of the manner in which the tribunal is going to interpret the recently amended provisions of the Act, the way that it will deal with excessive pricing cases in times of crisis going forward, and also practically how it is dealing with matters, the particular procedure that matters can be ventilated. This is the first excessive pricing case where the matter was determined on the papers with only some oral submissions made by way of remote video conferencing. For the continuing future, while we are in lockdown, that kind of procedure is going to follow. But I think that an important area of learning from this matter is that whereas excessive pricing cases normally take many, many years to finalize, we may be seeing some pressure from the tribunal to try and reduce the period within which matters are in fact finalized, and might want to consider how we present evidence in excessive pricing cases, that there might be a few more types of evidence that may be presented by way of affidavit. And in this particular matter, what is quite fortunate is that there was a lot of common cause on the facts. So there weren't major areas of dispute factually. And I think that the tribunal utilized that to leapfrog into its decisions that it made. And that assisted as well, I think, in being able to streamline the decision. I think what is evident from the judgment is that the tribunal specifically indicated those areas where admissions were made, where concessions were made, which I think would strengthen any case if it does have to go on appeal in due course. I think what the tribunal emphasized was that each case must be determined on a case-by-case basis. That's nothing new. And it also placed great emphasis on the fact that this matter must be considered within the prism of COVID-19. But as Professor Sutherland has indicated, that the matter wasn't determined at all with reference to the regulations. Even the process that was involved, the transacted time periods and procedure, was not in terms of the regulations or even the COVID-19 tribunal rules. So the tribunal has taken quite a strong stance on its ability to regulate its own procedure and how it's able to hear matters. It's also taken quite a bold and firm stance in some of the decisions that it's made. If you look at what it has said in relation to the determination of dominance, the the need or lack of need for market delineation and the simple economic test that is to be applied. I think something that I think that is particularly striking in this matter is if you consider Babelegi in the course of the hearing and some of the media statements that have been received post this judgment have critiqued the fact that Babelegi is an unknown family-run firm. It's not an industrial giant like Sasol or Mittal, who the Commission has previously litigated against. But I think that this judgment makes it very clear that Section 8, that the Act's abuse of dominance provisions apply equally to everybody if you qualify in terms of 6 and 7 of the Act. So if you have an annual turnover of 5 million rand or more, you meet the threshold set by the Minister. If the complaint relates to a situation that you have market power, not necessarily market share, if you are able to control prices, exclude competition, behave, as the definition in Section 1 says, to an appreciable extent independently of your competitors, customers or suppliers, if you want to hike your prices up by 888%, then you may be prosecuted in terms of Section 8. You don't have to be an industrial giant. If you are a small or medium business, you're not excluded from the application of Section 8. I don't really want to go too much into detail on the particular findings. I think we'll delve into that a little bit later. But I think, as I've indicated, the market delineation aspect, the lack of a need to determine market share is a particularly important finding that we're going to see significant repercussions following that. And that, I think, is something that's not limited to a crisis situation. That will apply outside of a crisis situation as well. And for that reason is very important going forward. Disappointingly, I think the tribunal didn't address the particular threshold in reasonableness. The Commission suggested that a 10% variation be considered. So that is an ongoing issue for debate. And then if I could just touch briefly on the issue of the administrative penalty imposed. I do believe that the penalty imposed is disappointing. I am concerned that it may not have the specific or general deterrent effect that the tribunal considered that it would. But we certainly have been given a clear indication by the tribunal that it has a strong preference for the 6-stage Gouging process for determination of an appropriate administrative penalty. And it's also placed strong reliance on the EU guidelines and how that then, if the administrative penalty is not appropriate in terms of that test, how it can be adjusted. And I think that's the way the tribunal is going to move forward on similar matters. Thank you.
Thank you very much, Candice, for those opening remarks. Indeed, in my view, it looks like quite a seminal matter. This, but I will like to hear from Pam, who has worked extensively before on these matters, Sasol in particular, and has gone to write about what she thinks ought to be the appropriate standard for excess pricing in developing economies, South Africa, and the world at large. Pam, over to you.
Thank you, Hadin, and good morning to everyone. I think I'd also like to start off my remarks by congratulating all the parties involved. I think prior to this case, I would have never thought that it was possible to run an excessive pricing case in such a short period of time. Trust me, the Sasol case took up a large part of my life. So that this can be done in a matter of weeks is just mind-blowing. I'm going to touch on a few things and hopefully be able to come back to some other things as we start engaging with the other panelists. But I mean, this decision is interesting for quite a number of reasons. And I think the first thing that really struck me was that the case was run as a straight excessive pricing case, right? With the stark differences with the circumstances in this case to the cases that we would have seen previously. But even having said that, the case and the way the tribunal engages with it shows that there are lessons that are being taken from the previous cases. And one of those things is the issue of the importance of context, right? So in Mittal, in Sasol, it was all around, these were infant industry supported firms, they had entrenched dominance. That was the context that mattered. And here the context is very different, but this context of the conduct happening during the crisis is very relevant and should be considered in engaging both with the selection of the types of cases that the authorities look at, as well as the assessment of the cases. And I mean, Hadin, you just mentioned the issues that I've raised in previous papers that I've written. Under normal circumstances, and primarily to avoid the cost of over-enforcement, and this is both in terms of the literature and case precedents, there have been a narrow set of circumstances that have been identified where competition authorities can pursue cases. And this has been included issues such as where there's entrenched dominance, where the dominance is durable with high barriers to entry, where a dominant company or firm implements a drastic sudden increase in price without an increase in costs. And and this is particularly, I think, concerning where where demand is inelastic. So now some of those issues are relevant here and some of them aren't, but I think that it's a good thing that the case was pursued. And the issues raised, particularly around dominance, are very interesting, and I'm going to come back to this, but very relevant. I think what I want to do is start with the economic tests, right, which is probably the most interesting perspective for economists that will be interested. So the main economic test that was used by the Commission to establish its prima facie case was the comparison of margins before and during the complaint period. And indeed, if you look at the kind of numbers that are in the decision, which are significantly above 500%, that those are extreme. And if you look at past cases that have been assessed, you've often been talking about differences between the excessive price and the competitive price ranging between 25% and over 500%. So you are clearly in the arena where competition authorities should be concerned that there's an issues when you're seeing margins at this level. Now, ordinarily, when you're looking at those differences, you'd be focusing on economic costs, and I think Prof. Sutherland touched on the lessons from Sasol for this. And though they were not engaged with here, I mean, I don't imagine the kind of additional economic costs that would significantly reduce that kind of margin. So in the Sasol case, for instance, with Sasol's head office, with its offices all over the world, all those group costs having been apportioned to the products that were under consideration, that was still a very small fraction of the overall cost. Issues that may increase the economic cost would have been return on capital, etc. But because this is a wholesale and retail type of business, you're not, seeking a return on R&D and innovation, and you're not seeing also significant infrastructure investments. So even if the tribunal had engaged more extensively with the discussion around economic costs, I don't believe that would have changed things quite significantly. I, however, would have liked to see within the decision some discussion around what else was happening in the market. So, for instance, I think the tribunal says, it's not relevant to consider what other players in the market were charging at the time. But I think it would have been quite useful, and this is something that the respondent could have raised. I think in the Sasol Chemical Industries case, there was this issue of the preponderance of evidence. So you need to, kind of show on as many tests as as possible that there is an excessive price. So the respondent could have, brought a case and showed what the other players in the market were charging. And I think it's particularly interesting because the margin actually does decline to 25% towards the end of the period. So for me, that sparks some interest on what else was happening around that market. And I think it would have been a relevant factor to consider. But just to be clear, I mean, I believe that, margins around that 500% are extreme and should be dealt with, and definitely would be considering as showing a prima facie case of excessive pricing. The other point then that's quite interesting to economists is the issue of dominance. I think this is the first case in South Africa, at least, where there's been a finding of temporary dominance. And having a quick look, I may have missed some other cases. It seems there's only one other case in Europe, which was the ABG oil case, where there was a finding of temporary dominance. Now that case was overturned, but however, how the case was overturned was not on the dominance issue. So it's kind of like silent on whether that is, that goes ahead or was an issue. So South Africa really is a pioneer in this area then, because there's no a standing precedence on this issue. And on that, I think from an economics perspective, there's definitely situations where you can have temporary dominance. And something like a health crisis certainly gives rise to those types of issues. There are a few more interesting questions that popped up in my mind as I was engaging with that I would have liked for the decision to engage with. But I mean, I don't know to what extent the parties would have raised the issues. But it's really going to be interesting to see how we engage going forward on the issue on temporary dominance. But reflecting on how that would affect normal excessive pricing cases, as in post COVID-19, I don't think that will be a big issue. I think we would go back to pursuing, your entrenched dominant firms at that point. And then I think a few of the panelists have raised the issue of detriment to consumers, and I wasn't going to speak on this, but now I feel pushed that I must talk about this. And I think for me, it is important that that's a step and that is explicit, because previously we've had situations where issues that are, in the preamble or that should be understood don't really get taken into account when decisions are being taken. So the fact that it is there explicit in the Act is quite useful and important, because it means that in every situation it will be considered. Now, what is the kind of difference that considering purchasers or customers other than consumers bring to that debate? And it brings to the debate what the type of competition that you value and the kind of competitive outcomes that you value for the country. And including customers and purchasers particularly says you value rivalry and you value customers and you value participation and that people are in the market. And I think particularly for a country like South Africa, that is a very important consideration, and it's good that we are now at a place that we are engaging explicitly at that level, because I do believe even in previous cases, there's been a lot of discussion. So for instance, in the Sasol matter, there was a lot of discussion around the effect on the customers, on Sasol's customers, rather than the end consumer who would be, buying a plastic product per se. I think I'll leave it there for now, and then I can come in at a later point with other points that I have once the other panelists have made their opening remarks.
No, thank you for those very thought-provoking remarks. I've been going through this judgment myself because, over and over, as you say, it's 500% or over. We hope this is not set as a standard that for authorities to pursue cases, margins should be at those levels. But I'm happy that the judgment is balanced, and it's quite clear that these are special circumstances under the COVID crisis. But it does make I think, important points that we will take forwards even beyond the crisis. And to take this further, I have Nkonzo as a practitioner, because I'm quite keen to hear what the practitioners think of this judgment. Has it provided much needed certainty, or do you think it raises more questions than answers? Gonzo.
Thanks, Adin. I'm not sure if I represent practitioners. I think I'll articulate personal views in this regard, because some of my colleagues may not want to identify with my views. The panelists that have gone before me have raised quite a number of issues that I would have liked to raise. I'll just emphasize a couple of those. The first issue for me is the application of Section 7C, where the tribunal seeks to define dominance merely in respect of market power. I think it is quite critical to look at the structure of Section 7. A firm is dominant in a market. It can never be dominant in a vacuum. Section 7C itself has two elements. The first element is obviously that the firm must have a certain market share in a particular market, and then it must be able to exercise market power. I don't think you can apply the one element and completely disregard the other. So the point I'm making is that I think as a matter of legal standard, the tribunal is required to determine the relevant market. There must be a definition of the market. I don't really know whether or not you can get away from that. That seems to be the legal provision, and consequently failing to actually apply that provision is likely to be quite fatal. So that's just my view. The second point that I want to go to, actually, this is where I should have started, to commend the Commission for bringing these proceedings, and to also commend the Minister for enacting the regulations in question, although they are not applied here. But clearly, the Commission initiated these proceedings on the basis of those regulations. I think it is quite important to be quite efficient and quite quick in dealing with issues of this nature, because of the public concerns around the mask at the time. However, despite that, I'm actually concerned about the fact that although this matter was brought on the basis of these regulations, the tribunal quite easily and stepped aside from interrogating the applicability of the regulations. The bottom line is that the respondent was given only a few days within which to respond to the Commission's referral affidavit. That's the bottom line. That raises fundamental questions about their due process rights, as to whether or not these were properly afforded to them. It is one thing that they were given an extension, but if you look at the extension itself, it's a very short extension. And we must ask the fundamental question: what was the rush with hearing this matter? The conduct had actually ceased. Where was the agency, both on the part of the Commission as well as on the part of the tribunal? Where exactly was the agency? The conduct had ceased at the time of the initiation of these proceedings. So I think that is going to remain a fundamental question. It is limited to this. It is only limited, as I admit, to these proceedings, because in subsequent proceedings this may not be an issue. So let's just park that. The third point I'd like to raise is that I think it is quite important to adopt a purposive interpretation of the dominance provisions of the Competition Act. These provisions were aimed at dealing with parties that were abusing their size to distort competition in the market. I think that was the overall objective of those provisions. And consequently, this application of 7C, which captures such a small entity, is very problematic. You know, the outcome, I mean, the idea of successfully prosecuting an entity on the basis of dominance, I think is important. I recognize that. But it is quite unfortunate that we're doing that in respect of an entity that is probably less than 5% in size. You know, what this means is that, in effect, even if you have less than 1% of the market, when this issue of temporary dominance arises in your context, you could actually be held to be a dominant firm. I strongly think, colleagues, that that is very unfortunate. You know, when you follow the strict reading of 7C, you may indeed come to the conclusion that even if you have 1%, you are nevertheless dominant because you have market power. That's just very, very unfortunate. You know, it would be very unfortunate if this decision stands in circumstances where, when you look at the overall purpose of the provisions, you can clearly see that they were aimed at dealing with entities that were abusing their size. The last point that I'd like to raise is the point that Professor Sutherland raised in relation to this price gouging decisions and jurisprudence that flows from overseas. I think to a certain extent it might be useful to look at it. But the bottom line, colleagues, is that we have no such provision. We have no price gouging provisions in South Africa. That should be our starting point when we interrogate these things. You know, looking at the decision, looking at how, you know, the tribunal was making constant reference to this, obviously based on the submissions of the commission. I think that is very problematic. South Africa does not have price gouging provisions, and consequently it is important to stay faithful to our text. Our text has excessive pricing provisions. And I'm really happy that the tribunal actually grappled with the application of Section 8 itself in dealing with this, instead of relying on the emergency regulations, because I think there were problems there. Chair, let me stop there at this point in time. Thank you.
No, thank you very much, Nkonzo. I think, of course, I'm going to bring in the economists because you make an emphatic statement. There must be a definition of the market. So for one to even think of market power, there must be a definition of the market. And I'm happy, you know, it's a very, and I'll bring these other procedural issues to my lawyer panels, because when I read this, the tribunal simply said, you know, it has a wider discretion in terms of Section 27 on how it should decide urgency, you know, read with Rule 55. So it's a very refreshing way of looking at proceedings. This, and I'm hoping the eminent economist, I think Massimo has been quoted, Professor Mota has been quoted. I think he's the most quoted scholar or economist in our courts, from the authorities, tribunal, competition appeal court, constitutional court judgments. All of these judgments, if you read all the core judgments, be it excessive pricing, predatory pricing, you will find a citation of Professor Mota. And our universities, I'm sure a lot of his students have also joined us today. So Professor Mota, on that, I think Nkonzo says emphatically, there must be a definition of the market to determine market power. I hand over to you.
Thanks, Ardeen. Thank you very much. What a responsibility, right? So I have to be very careful about what I'm going to say now. I will come to market definition, and I will come to some of the points which have been raised before by the other panelists, which to a large extent I share. But let me start a little bit from the beginning. That is that a general judgment on this decision, which I think it's a very good decision. It's a very good judgment, which doesn't surprise me because the Competition Tribunal has accustomed us to a very high level, a very high quality of its decisions. They are always very well reasoned and very well balanced. So, this is in line with a long tradition, I think. But let me therefore stick not so much, let me focus on what are the more, say, to my mind, controversial aspects of this decision. And many of them are related to the concept of dominance. Perhaps later on, I will, if there is a second chance later, I will address also some of the other issues like on penalties, on thresholds, etc. But perhaps to start with, I would like to stay on the issue of dominance. And so there is one thing which concerns me about the tribunal decision, and which is something that can be seen from the conclusion on market power and dominance and prima facie case that you have at paragraphs 151 of the judgment and following. Already the structure of these conclusions tells you what makes me a little bit uncomfortable with the judgment, which is that first it says that there is market power, and there has been basically prices which are extremely high and therefore excessive, and then on the basis of this, it finds that there is dominance. So there is a sentence, for instance, which says, based on the evidence of its own conduct and considering the context of COVID-19, one can reasonably infer that Babelegi had market power during the complaint period, etc., etc., etc. So this is a little bit the construction which makes me a little bit worried for the future. In this particular case, I think, as I said, I agree with what has happened, etc. But I would have preferred to stress two things. First, to stress even more the context of the COVID crisis, which of course it's in the background, but I think it should have been stressed a little even more. That is, that something which is very particular to the particular way in which the decision was taken. And second, the issue of dominance. I would have preferred to do it in a different way. That is, I would have preferred to define the market, and from there to establish dominance, and then to go into abuse. Now, and here I come to the issue which has been raised by previous panelists, which is market definition in this particular case. Now, at some point in the judgment, it is written explicitly that in the case at hand, given the difficulties of the crisis created by the crisis, etc., it would be very difficult or impossible to use the SNP test, the test, the hypothetical monopolies test, which is what we typically use in competition in order to establish the definition of the market. I think there was, the first thing to say is that the SNP test, it's not a practical test by itself. So it's a hypothetical test, and you should think about it as a way to organize your thoughts rather than something which is of direct implementation. So in this particular case, I would have started with the SNP test and say, look, what is the market where Babelegi is typically selling to? There is not enough information about the judgment for me to know exactly how it should be framed. There is extremely little about the customers of Babelegi. There is very little about where it sends, etc. And this reminds me of some of the comments which had been made previously, that is that it would have been nicer to have a little bit more information about the market, about demand, about what other firms are doing, etc. But let me go back to that. So suppose that this company typically sells to clients who are located within, say, 10 kilometers from where it is established. And then you would apply the test that says, would it be possible? There you have to specify in these particular circumstances, not abstracting from the market, but in the particular circumstances of the COVID-19 crisis, would it be possible for a hypothetical monopolist to increase the prices in the order of 5 or 10%? So this was basically the question, and then probably the answer would have been, even looking at what actual consumers have done, etc. Well, yes, it was possible, because what happens is that the consumers didn't have much of a choice, because other firms were constrained and could not supply face masks of the same type, because there were already some suppliers which have said that they were running out of stock, etc. So I think that in these particular circumstances, although it was difficult, then you could have used the SNP test, and the answer to the SNP test would have been, yes, we can define the market in these particular circumstances in this narrow way, whether it is 10 kilometers away from the plant or whatever, or the outlet of Babelegi, I do not know, as I said, but I think it was possible to start in this way. And I think I would have preferred it in this way, because I am a little bit afraid of this sort of circularity argument, which is we sidestep the market definition, we observe that there is a particular conduct. If we observe this conduct, then it must mean that the firm is dominant. And it's important to stress, as all the previous panelists have done, that this particular judgment is not in the context of the consumer protection regulation. Here we are just applying the act, and therefore, presumably, it is a precedent to be followed for similar cases in the future. So as a consequence, I'm very much afraid that in the future, by using this way of proceeding, then somebody could say, okay, here there is Mr. So-and-so is increasing the price by a certain amount. Well, if it is increasing the price, say even 50%, 100%, 10%, whatever it is, with respect to what is normally done, then this is excessive, and so Mr. So-and-so is dominant. That is not the way in which I think that we should go. So this is why I would have preferred, to have to start from the beginning and not inferring dominance from conduct. I repeat, I don't have any particular problems with the conclusions at which the judgment has arrived. My suggestion would have been, do the standard way, because even in the standard way, you would have found exactly the same. And again, to repeat, I'm a little bit afraid about possible misinterpretation of this precedent in the future. I'm pretty sure that the competition tribunal would not do it again, but there is also an issue about providing legal certainty to firms. There might be firms out there who are going to be, worrying and saying, well, now, if you start to say that you can infer dominance from abuse, well, I am using bundling. So I'm very tiny, but I'm using bundling. Can somebody say that I'm dominant just because I'm doing bundling or because I'm engaging in exclusive contracts, etc., etc.? Okay. So I think I will stop here. I have other points, but I think at this point it's better to give the mic back to the other speakers. Thanks.
No, so thank you, Professor Mott. I think your message is quite clear, and I think it's really cautioning against the unintended consequences, not so much the outcome of this particular decision. I think which we take positively, and on this note, because this issue of dominance, I think James, the Commission's chief economist, can then chip in and share his thoughts on the decision. Someone was involved, but also reflecting also on the process as well. James, over to you.
Thanks, Hardin. And coming last, there's a lot has been said already, and so I'll be brief. I think in terms of what this case sort of ultimately does is that the tribunal gets, in my mind, maybe three important things right: context, identifying what is relevant in this context, and that is partly a legal interpretation of 8.3. But I also think what hasn't been highlighted by the other panelists is the importance of the shift of onus in this case. Because ultimately this case, I think, is self-explanatory, and there are very few commentators out there who think that this behavior was, acceptable in the current context, and that there was a rational economic reason for it, or that it had any unintended consequences prosecuting this case. But the importance, and let me start with the shift in onus, has always been that very often we find in these sort of abuse of dominance cases that there isn't an acceptable rationale for the behavior, and that too much energy is focused on whether the Commission can overcome many different hurdles in order to demonstrate effects or define the market or prove dominance. But ultimately, when we strip that away, there isn't a rationale for the behavior other than exploitation of that temporary position in this case. So by putting a spotlight on what is that rationale and is there a rationale, I think that's an important part of the judgment, and an important part maybe going forward that will remain with us in future decisions, that there will be more emphasis placed on, can you explain this behavior? And can you explain it as efficiency enhancing or beneficial to consumers or customers in the short run or the long run? Maybe to go back then to context and relevance. We've now had a few of these cases, and maybe the judgment brings through some of the debate amongst the economists. But I think importantly, what has happened in the first few cases is often the economists for the respondent have focused on exactly the precedent. We should only be concerned about entrenched dominance. That is what the economists say, and this is the sort of rule book or things we must do in order to assess that. Including we must look at cost. We must look at all these relevant costs or potentially relevant. And why I raise that as an important element is the tribunal, I think, correctly strips away some of that unnecessary complexity in this case and says, well, that isn't relevant to this case. It's not demonstrably relevant, and we can use, in fact, a simple economic test in order to assess this. And so in the context, certainly, of an emergency, this is entirely correct, because to waste our time undertaking sort of tests from precedent where we would just delay any case for literally years in order to undertake that when it's ultimately not relevant or determinative, actually defeats justice in the end, because this needs to happen fast in this context. And that's where I think, you know, I would maybe disagree with the professor on this, that some of the sort of snip test thinking, you know, we can go through that exercise, but ultimately when we have a demonstrable sort of increase in price that gets bolder and bolder, as the tribunal put it, over a period, are we just setting up sort of tests for the sake of it, or is it ultimately going to be instrumental in understanding this market and the behavior and whether we should act? You know, we were, I recall, as the Commission, criticised by the Judge President at our own conference last year, and that you must be careful in inviting certain guests, clearly, but we were criticised in the context of the predatory pricing case that reached the CAC for being unnecessarily complex. That this is a field where we are almost looking for every possible element must be tested and assessed before we can bring a case. And I think this stands out as a ruling which takes a simplicity and arrives at the correct decision, if you ask me. I know there will be concerns, and Massimo expresses about what happens going forward, but I think we can trust the tribunal and the courts to differentiate different circumstances. And so there are cases of entrenched dominance we've got to worry about, but there's also abuse in a crisis. And I may, you know, also speculate that probably what we also start to see, and we are seeing now in terms of food and some of the complaints coming through, is you might also get dominance in small rural towns, which doesn't have the flavor of an industrial giant. And maybe the predatory pricing case was exactly that. Although there was a giant behind those community newspapers, it played out on a small scale, on a small stage. And very often, I think we are focused as economists and practitioners on a national stage and forget about some of the smaller rural dynamics as well. So this might hold implications for how we look at other parts of the economy as well. But I would trust that the Commission and the Tribunal is able to differentiate these different circumstances and use then the economics sensibly. What is not sensible, and which I think the Tribunal rightly rejected, is to take this sort of checklist approach to casework and say, well, this is how it should be thought about because we had one case like this previously, and these are the processes we must go through. So my view is if there are big takeaways for me, context matters, relevance of factors matters, shift in onus matters. I think lastly, just to tie up on dominance and market power, I mean, we put in market shares as a sort of simplifying device, but it's almost become a crutch that we rely on in South Africa. But in other jurisdictions, market power isn't defined in respect of market shares. And I think this is a welcome change. And I think as we move into areas like buyer power in future, we are going to have to rely more on assessing, are there elements of market power that we can demonstrably see. And this is important, I think, in an abuse context, which in part of our submissions to the tribunal, we noted that in an abuse context, you have behavior that's been taken place. You can look ex post and assess on behavior. In merger control, when you're looking forward and forecasting, maybe defining a market is more important in that context because you're trying to predict. But where you have actual behavior, you know, that speaks volumes about what is possible and whether those firms do have a degree of independence from other competitors and customers. Thank you.
Yeah, thank you, James. Indeed, as you say context matters, and this is what the tribunal, you say, got right on this matter. And And I will, of course, because I think it's getting quite interesting now on the panel. I think we have a sense of what are the contentious issues, and what I'll do now is to check with the audience. I understand we have around 160 people who have joined us from across the world, so we can check, Sipho, if there are any questions at this moment for the panel. Otherwise, then I will get back to the discussion.
There are 3 questions from the audience.
3 questions?
Yes.
Okay, please read them through, then we'll see who can take.
So the first one relates to the applicability of the Competition Act and whether the Commission would be able to act in cases where suppliers and circumstances where the customer was the state. And I think it's just a question of clarity as to whether those transactions would be covered in this instance by the Competition Act. The second question is how difficult it was to pass the dominance test. I think it may have been answered, but if the panel want to continue in that regard. The third question is on the SNP test. This is aimed at Prof. Mota. The understanding is that you cannot rely on the SIP test in defining a market in excessive pricing cases because of the cellophane fallacy problem. And the attendant wants to know how the professor suggests this would work in these cases. These are the 3 questions that we've received thus far.
Okay, I think there's one specifically to Professor Mota. Maybe you can start, but I think panel members can then chip in. If you want to take any of the questions, then just indicate, and then we'll take it like that.
So thanks for the question. The issue is the following, that is that when you are looking at an abuse of dominance case, you have to be careful about what is the price that you use as a base price. That is, you cannot use the current price, which is charged by the defendant, and say would the hypothetical monopolist increase the price by 10%, because in some cases it's already the monopolist itself. So the way in which you do the SNP test in this case is by using as a base price what would be the sort of the competitive price. In this particular case, you would have done it saying, look, let's look at what are the costs of hypothetical monopolist in this particular case, whether it is hypothetical or actual, then at that point it doesn't matter. And could that hypothetical monopolist increase the price by 10%? Now, and this is, I agree with, so this is the way in which you do it in abuse of dominance cases. So this brings me a little bit to the remarks that James was making before. To a very large extent, I agree with the remarks that James that you were making, particularly the remarks about complexity, etc. But my point is precisely that I don't think that in this particular case it would have been extremely difficult to just use the simple approach. That is, you could have started in this way and say, look, let's see. In this particular case, we know what the cost would have been for a hypothetical monopolist. Could the hypothetical monopolist increase the price? And then inform the answer by what you have actually seen in reality. But in the process, you would have already described a little bit more what is happening around the company, what are doing the consumers or the customers that the company has, etc. And sure enough, the fact that it was able to increase the prices so massively was certainly informing already your answer. So I perfectly agree about the comments about not going into complexity. And that's precisely why I think in this particular case it was not necessary to invert the order of the way in which you should proceed and infer dominance from abuse, because it was precisely not necessary. So linking on that, in particular, a comment on the test, which is also something which has been raised by the previous panelists in different points. I think that one of the problems with the previous judgments in the area of excessive prices in South Africa is that they were too confusing, and that they didn't, they made a mess, if I am allowed to say so, of how to proceed in such cases, invoking something like long-run competitive equilibrium prices, very abstract concepts, etc. I think that the way in which one should proceed in these cases, and which is basically on the reasonableness, what the Competition Tribunal has done commendably in this particular case, is to say, look, you can approximate economic value by two things. One is prices, which would prevail in normally, effective competition cases, and two, by the cost of the company. In this particular case, what the tribunal has done is basically both, because it had I basically used a time series. It used as a benchmark the prices before the crisis, and it was right to do so. And he said, well, the price increases are, the order of 5 to 9 times, and therefore clearly here, the price leg, if you want, the economic value as a price benchmark is satisfied. When he looked at the price cost the ratio, that is the margin, and he found exactly the same. So basically, the way in which he proceeded, to my mind, was linear, was very correct. It was not particularly complex, and it was in line with what, in my opinion, should be done in these cases. Thank you.
No, thank you very much, Professor Mota. Anyone to take any of the questions, any of the panel members? Nkonzo, yes. I think the camera can go to Nkonzo. And then Candice.
Okay. Yeah, just in respect of the first question about whether or not these regulations will be applicable to entities that are part of the state. It's a very simple answer in terms of Section 81 of the Act, the shortest provision of the Act. It simply says this Act binds the state. So we would expect that any entity that is part of the state would be required to comply with these regulations.
Right. No, thank you very much, Nkonzo. Candice?
Thank you. Yes, if the customer or consumer, or presumably it will be the customer who is the state, the provisions are also going to be applying. And I think something that is evident from this judgment is that the tribunal has emphasized the active role that competition authorities have to play, especially in relation to socioeconomic rights and public interest. If the state is going to be a customer in the context of COVID-19, it may well be buying items like masks to give to the general public, which is something that would make it critically important that it falls within these provisions.
No, thank you very much. It seems to me, I think the issues here are quite clear, and the amendments last year to the Competition Act have shifted the landscape, in my view. And the issue of onus, this is not what was there. The onus is now on the dominant firm. there's certain criterion that needs to be looked at to determine what could be an excessive price. And this is something that I think with or without this decision, changes were abound. Changes are already with us. This decision, I think, just came at the right moment when authorities or South Africa is ready to implement what I see as the second phase of the excessive pricing regulations or laws, after some challenges, as Professor Mota is saying, in Sasol, the concepts that were coming about were becoming increasingly difficult and sometimes confusing for even business to understand what is it that they should do if they want to do right, and when do they know when they've done wrong. I will allow now our panel to maybe make a forward-looking view on what the implication of this decision is broadly, not just in South Africa and globally, especially for all those people who have joined us today, and those that may watch this video in future. So I'm going to start with Pam. I'll give Pam the first bite.
I think one of the important things that the decision does, and that will have implications for how I think authorities all over the world may think around excessive pricings, are on two fronts. And I think this is something that Gonzo raised previously in his comments. He said that South Africa does not have price gouging regulations, and therefore the tribunal should not have made mention of this. But if you strip away the language, at the heart of it, the fundamental economics speaks to the same thing. You are dealing with the allocation of scarce resources, and you are just dealing it in different context. So what this decision does is says that you can actually look at those types of cases and those types of issues within the framework of excessive pricing. And I think this will be interesting to see then what other countries do going forward in this regard. I think the debate around assessment of dominance when you are looking at cases such as this within a particular crisis is going to be interesting in how it's taken forward by other cases, and whether it is brought even in South Africa again under different circumstances outside of a crisis. But I think, there's been a lot of talk in this discussion around how the amendments have made such big changes to the excessive pricing provisions. And I'm not of the same view. I think the most significant change to the provisions has been the change in the onus, and that is a significant change on its own. But in terms of the actual tests and measures for assessing excessive pricing, these have always been there. They've been there in all the various cases, and actually all the points that are now in the Act were in Natal, were considered and used in Sasol. I do agree with Massimo, though, that how the CAC-Mittal decision had framed the definition of economic value as long-run competitive equilibrium, then made the debate rather abstract. But how the Commission had argued that particular case, which now I think is reflected in the amended Act, was that actually what that means at the end of the day is you want effective competitive rivalry, right? So just competitive outcomes rather than modeling complicated scenarios. So I think these are themes that have always been there in the cases. What's now interesting and what's useful and what does make the assessment much easier for the Commission is the change in onus, because if you can just show that there is a prima facie case, then it will be the onus changes to the respondent to then bring about the new cases. I think it will be quite interesting, though, once you start having cases with your entrenched dominant firms, how they are going to deal and engage at that level.
Thank you, Pam, for those very insightful remarks. And I'm going to go to Candice for final remarks.
So I think that I've largely already addressed the primary issues that I think, well, I think not only in South Africa, but in the rest of the world, this is certainly going to be a point of reference as a case in excessive pricing matters. I think it's going to open the debate in, as Pam has said, in respect of the issue of dominance. The indication by the tribunal that there's no need for market delineation is something that's going to be an ongoing issue, as well as the appropriate economic test. Hopefully we won't have to deal too much in future with crises, but certainly it assists to have some guidelines in respect of the way forward. I think these amendments that have been affected, as Pam says, the primary difference is this reversal of onus. It's definitely going to allow for a streamlining of process. It's going to allow the Commission to be more efficient. But in the judgment, it's quite evident that the tribunal has grasped and emphasized the discretion that it has in terms of this. But that is going to be an ongoing debate in any event. I think it's going to depend on a case-by-case basis. What is more relevant which is a more relevant factor than another factor in the particular circumstances of the case. And I think there's still uncertainty in respect of what, or perhaps not uncertainty, but there will still be consideration of what an appropriate penalty is in a crisis situation. What is going to be a sufficient deterrence? The tribunal has clearly felt that a penalty at 1.5 times is sufficient. I think as Philip indicated earlier on, there may be an issue in this regard. There's no clear indication as to how that 1.5, in addition to the excess profit, is determined, and that's going to be an area of ongoing debate, both locally and I think internationally.
Thank you, Candice. So I'll go to Sentin Nkonzo.
Thank you, Chair. I actually found it quite interesting that Professor Mota made a point that ideally it would have been appropriate for the tribunal to start by dealing with the definition of the market before moving on to deal with the issue of market power. Indeed, as I said earlier, I think there's a problem there. It's something that has to be dealt with in future cases. I think the tribunal would have to be a bit more cautious and a bit more careful in that regard. I don't think it's a matter that you can just dismiss. As I said earlier, if you look at the specific wording of that section, it clearly gives rise to the impression that you'd first of all define a market so that you can say that that party is dominant in that particular market. If, for instance, you know, I was an arbiter in these cases. When you come up and you say there's an abuse of dominance here, I'll say, in what market? What market exactly are we dealing with before we come to the view that that particular party is in fact dominant? For me, I think going forward that would be critical. The other important learning that I have taken from this, as I said, I commended both the Commission and the Tribunal for dealing with this expeditiously, is that we would hopefully going forward manage to deal with these complex matters within a relatively short space of time. We know that in the first 20 years we dealt with only 2 matters of excessive pricing. Hopefully we can deal with more after the amendments, we were able to resolve this one. Hopefully, it will pass muster with the appeal court if it gets there. But that's an important learning, both from the fact that as a complainant, you want to see closure as quickly as possible, so that you can seek redress if you need to. So I think that's important for the Commission going forward in expediting these matters. They've come up with very good experience from this one, although the facts may have been very clear here. The other, which is my final thought, Chair, is in respect of this reference to context. And I think it is correct. It's just that the context may be controversial in some instances, but this is a finding of the tribunal. For instance, one of the questions that I asked myself was whether or not South Africans were entitled to go into a state of panic before the president declared a state of disaster in South Africa. That's a fundamental question. In fact, in my recollection, at the relevant time, the health advice from WHO was that healthy people didn't require masks. So in fact, we were told at the time that only people who were sick required these masks. So it's conceivable that the people who bought masks at the relevant time were people who were healthy who didn't really require masks. It was only on the 5th of March that there was the first case, COVID case. We could theoretically say that that person was entitled to buy a mask, but it was only one person. Thank you, Chair.
Thank you very much, Nkonzo. I think on this note, I'll give the floor to James, because the issue of rationality has always been there. Why do you eat more than 2 ice creams at a go? Why 3, 4? It's an issue that has been there, but I think James, as a practitioner of the Commission, he will probably deal with those issues, quite aptly. So James, over to you.
Thanks, Chair. I mean, maybe to exactly pick up that, I think there's a nice sentence in the ruling which said the regulations didn't create the crisis. It's the other way around. And so the regulations were a response to a crisis. And I think what has been useful out of this ruling is the use of Section 8 in its existing form without the need for regulations, because I think this is something that has been faced globally, that as was picked up in the ruling and also part of the evidence, the conditions were present for domestic dominance and panic buying because of the global crisis, and the global nature of it also was important in that. But maybe that question brings me back to a point I was making earlier, and I think all too often in these cases, the courts get tied up in speculation. And amongst economists, we have coined the phrase signal jamming behavior, which is really where respondents, economists come in and says, yes, but has the Commission considered this, or has it considered that, or is it not possible that this? These are not things that they seek to prove, but more to raise question. And it's also, I think, been pointed out, especially in the context of large global companies that seek to criticize authorities, and this has come up a lot in the digital world, is, well, often it's the respondent themselves that has the data to prove that one way or another. And the fact that they don't put up that evidence is because it doesn't favor them. And this goes back to this issue of unnecessary complexity in the cases. And why I like this ruling is it starts to strip away some of that behavior and say, let's just get to the core issue. And often the core issue is, can you explain this behavior and explain why it is reasonable? And there is a glaring gap. There is no answer in this case, and there's no answer in all of these price gouging cases. And as I indicated, there's no one who puts up their hands and says, this is a mistake. This is an error cost, so to speak, for a judgment. I think if we reflect 6 months down, that the rapid action of the Commission and the Tribunal in these cases and creating a deterrent effect as a result of these cases will be seen as something that has saved consumers billions, probably, you know, and especially in a context where consumers are losing their jobs and are facing extreme hardship. I mean, I'm reminded, Chair, that you sort of talked about Mike Walker and his article, but the CMA has said, it has gone to Parliament there and said, we have 60,000 complaints of price gouging. Now, that is a problem on a massive scale that has not been addressed. And in a recent OECD discussion, I think the point we made to many of these other authorities was the constraint is in their mind, it's not in the law. The constraint is because you have some precedent which has never had to deal with a pandemic, and that's become the conventional approach. But there's nothing in the law that restricts us, and nothing in the economics. We accept that price gouging, however you want to term it, is offensive. It doesn't have redeeming features, and so if it's condemned as part of a ruling, then that is not a cost to the economy, and it's not a error cost in the legal system. So let me end there.
Thank you, James. I think on that note, it will be quite up to take it to Philip, because he will probably answer this for us. Is this a signal jamming behavior that James is talking about? And he also says probably the constraint is in the mind. Philip, can you dissect that for us? I think I think I missed your hand earlier, but I think this you have sufficient time to go through this.
Absolutely no problem whatsoever. So let me then start with the point that you've just made. I think that the idea that some of these cases have been allowed to become too complicated is correct, and I think you will find a sympathetic ear in this when you have this conversation with members of the Competition Appeal Court sometimes as well, who say that sometimes the management of tribunal cases, in the interest of having all arguments put before the tribunal, they have become almost unmanageable. And that certainly has been true of the price, excessive pricing cases. And I know Dennis Davis told me one day that when he was reading through the record for the Sasol case, and at some stage he wanted to say, I'm just going to give up, this is too complicated. But I wonder if we don't have the sort of three bears problem here, that perhaps the porridge was too hot, and I think in some ways the porridge in this case for me is a little bit too cold, in the sense that I think the test that the tribunal followed here is a little bit basic, and I think it relates to the point that Massimo made, in the sense that you use exactly the same aspect to test for every single part of determining whether there is an excessive price. And I'm not quite convinced, and even if you could do it in this case, I'm not quite convinced whether this whether you couldn't perhaps explain some of this behavior in some other ways, and whether it really is a sort of QED type of situation necessarily. I mean, you are working with a fairly small firm in uncertain times, also just sort of finding its way where information is not clear, and I get the sense that perhaps one could have investigated those issues a little bit more carefully, and I wonder if part of the problem is not what Nkonzo has said, is that to some extent the Competition Commission brought this case initially as a regulation case, and then it became a pure Section 8 case within very strict parameters. And I mean, you are right, James, that I think the term that's the context is one of the terms most often used in this judgment, but the other phrase that's most often used is "this was not explained by the respondent," and that brings me to my second point, and that is this issue of the change with regards to onus in excessive pricing cases. It's an issue that I don't think I dealt with properly when I spoke about this initially. So I still wonder exactly what the onus shift is here. So firstly, and that takes us back to the market definition part, is of course the change of onus does not at all relate to the determinants of dominance. So the dominance part, there the onus still lies with the Commission, and I don't think the Tribunal confused it in any way, but I think that should be stated clearly. Moreover, if a proper market definition is not done, then the strict onus to prove dominance will be on the Commission, because they don't use the benefit of that they would have if they could show large market shares. So I also think if you talk about this issue of not doing market definition, it should be kept in mind that in this case, market definition was not really done, and in the process, of course, the Commission had to concede that the onus had to be on them to prove dominance. When it comes to the market definition issue itself, it's interesting to me that the SNP test is only mentioned once in the case, and that is in the context of the respondents' economists saying we should actually apply the SNP test before the emergency in defining a market. Now, I must say I don't agree with that. I think that, of course, even if you say market definition is necessary here, you have to do it in the context of the emergency. It could be relevant to define it before as well, but you at least would have to, that would be the most relevant market definition. I also find it slightly peculiar that no market definition was done here, although I think the Tribunal is correct to suggest that it wouldn't always be necessary. But I would think that this would be a case where they should have done it. One can have a lot of debates about the importance of market definition here, whether you really need the 3 stages, but I think there are good arguments that it is a systematic way of dealing with the issues. Then, when it comes to this question of gouging, Pamela, you mentioned it as well. You know, why can't they rely on gouging? I think one has to be careful here, and there are 2 reasons for that. The one is that mostly price gouging laws do not require dominance, and one can say that the price gouging laws are there to limit the mechanisms of the market for reasons that lie outside of the operation of the market. So in that sense, price gouging legislation does not really have the same purpose as competition law. And I think it's a bit dangerous to see them as overlapping, although in this case, the respondent conceded that price gouging is a form of excessive pricing. I would be a little bit more cautious in saying that. So what you say in price gouging is say, even if the market operates competitively in an emergency, we don't trust the consequences of that, and therefore we make laws for that. And you can't do that in competition law. And the second aspect, I think that's very important, and that's not properly, for me, discounted in this case, is that price gouging laws generally set up a very clear, it tells you from what point in time you are price gouging, and secondly, it normally sets a clear standard for what price gouging would constitute. So as a typical academic, I would say, in this case, it probably would have been better for us from the outside to say, as they did in Turkey, you set out a specific price gouging regulation and you give it to the Commission to enforce. Because as Massimo points out, I can understand that the Minister passed it on to the Commission as one of the most efficient institutions in South Africa, but I wondered if the right way of doing it was using competition law for the purpose. Then I think if they did market definition here, they could have also addressed some of the other issues, like the issue of face masks, and whether the face masks that were produced here were really the ones that weren't medically necessary. I think some of those problems could have been actually sorted out more easily if market definition was done here. And the other aspect that I think it's important from this case going forward is the tribunal specifically said we don't necessarily have to consider all those factors in A3. And we can, in the context, decide which ones are important. And they then stressed the pre and post price, the test, James. That I think it's your test, and I think that's right as well. Although I think the tribunal will in future have to be very cautious if they do not look at other factors. So they at least would have to give some clear reason why they exclude certain factors or emphasize others. But I think in that respect, they clearly have some discretion. For the other aspect from this case that I think may be important, let me make two more small points. First point I want to make is the tribunal makes the point that the intention of the respondent is not relevant. So it excludes the requirement of mens rea here. And I think that's going forward is going to be an important issue. And then the last point that I just want to relate to Candice is I don't think the Commission should be too concerned about the fine here being too low. I personally don't think it's too low. And I think, again, context is important here. One must compare the fine to the fact that it is a very small business, having a small profit. I think the idea of, personally, I think the idea of taking a year's profits here would be problematic. One of the problems you're going to have in future is how do you apply the 10% threshold if you look backwards to firms' profits and you consider what happened to them in this COVID year, in the context of penalties and thinking about COVID. I think that's one of the issues you're going to have. So I wouldn't beat myself up about the size of the fine. You must consider it in the context of the size of the firm. So those are my short points.
Thank you very much. Thank you very much, Philip. At least we know that we are dealing here with FFP1 masks. I've come to learn that there are dust masks, there are surgical masks, there are different types of masks. Whether that is a product or a market, I'll leave it for experts to debate as we go along. So we will, I think, give Professor Motta the last word. I think the issue of the changes in the law, I think the changes are there. The tribunal has said it's a functionary, it's got discretion to consider relevant factors, and in this case, it did rule as it did. So, Professor Motta, you have the final words. You say you have, you reminded me that you have special responsibilities in the competition world. So I thought it's appropriate to give you the last word. So you have the last word.
Thanks, Sardine, but next time I want to speak before Philip, because basically Philip has covered all, so it's very difficult now not to differentiate from him. So I just want to conclude with a couple of comments and then one conclusive remark. One comment is something that we have, or at least I have not talked about before, which is about the necessary threshold for excessiveness or for unreasonableness. So I think that the Competition Tribunal got it right in not saying exactly where the line should be. I think that's not for the tribunal to do it, and so in this respect, I think they did it right. I am also thankful that the tribunal didn't say that the 10% threshold is good, because I think it would not be the right threshold. That I think it would be too small of a threshold in order to justify an excessive price case. I think, again, here we are not in the context of consumer protection regulations, we are in the context of the Act, and I think we have to recall what we are talking about, which is, excessive prices is really something we should bear no reasonable proportion with cost of benchmark pricing. Talking about small increases of the order of 10% wouldn't seem to me the right thing. So I hope that the Commission, now that the precedent has been set, can focus on cases where the price increases are not of the order of 10%, but clearly on much more significant. So that was one thing. On the other thing, which Philip in part has already touched upon, on which I think that the Tribunal has got it right, is on the penalty. I think overall the penalty is well balanced, and with respect to the step procedure which is typically used, and here I'm basically going to what Philip, I guess, was saying before. If you have to start from the last year turnover, and last year turnover was 100, while this year you can charge prices which are 10 times or 50 times higher, that clearly starting the calculation of the fine from that turnover, which is that small, cannot be the right thing, because it will never lead you to have a proper deterrence. So I think that it's more than fair that the Tribunal has decided to integrate the way of proceeding by taking into account also the profits that the firm did during the conduct and the period at issue. Finally, that's the last remark. I want to say again, I focused also for the sake of having a discussion and conversation, because otherwise it would be too boring to say the way you all agree. So I focused on one element on which I was in partial disagreement, or rather that it worries me a little bit more. But I think it is a good decision, and I think that the Competition Commission and the Tribunal have done an excellent job. Again, the only thing which worries me a little bit is this fact that looking forward, that there is no precedent about having the conduct being sufficient to establish that there is also dominance. To a large extent, I'm indifferent whether you want to go for market power directly or to go for the definition of the relevant market first. In this particular case, it could have been done in a traditional way, so I would have not seen the necessity of sidestepping the market definition stage. In other cases, it might be different. But what is important is to understand exactly how come that a firm has a dominant position, how come that a firm has market power, how come that a firm can really behave independently of rivals, competitors and consumers. That is the crucial thing, and that is in a way understanding a little bit more how the market works, etc. Thank you very much.
Thank you very much, Professor Mota, for those remarks. I think it closes it well. It answers even Philip's question: is the porridge too cold or too hot? I think he got the answer now. I think it's manageable. I think it's a fair decision, as you have said, and it does provide clarity on a whole lot of other questions that we have had in South Africa. And of course, this is not the last of it. We will be, hearing most of it, of excessive pricing in South Africa into the future. We awaited decision in this camp, similar circumstances. So we keenly, await to hear what the Tribunal says on those matters. I do thank the panel for making the time. We truly appreciate it. For Professor Mota, this is the second time. So if we were not in COVID, we would have probably not been able to fly you in, but we have been able to get you here without much hassles. I think Professor Sutherland wouldn't have liked to leave Stellenbosch just for 2 hours to come to Pretoria. So the circumstances do allow for many other great possibilities. So we really thank you for that. And I do thank the participants, the about 160 participants who joined us today. I hope you learned a thing or two, and you got to understand better the ruling of the tribunal on this. And there's a producer whom you have not been able to see. It's Itebuheng Palare. Thank you very much, Itebuheng, for arranging this and making this possible. And I was doing this, ably assisted by Sipom Tombeni. I do thank my team for assisting us here. So I hope this recording would be freely available. We will share it in our social media platforms. You will be able to refer to it into the future as we further reflect on this matter. Thank you very much to the panel again for making the time. Thank you very much.
Thank you.
Have a pleasant day further.
Thanks. Thanks.
Thank you.